Nancy Skovholt has practiced with Ensberg Law Group in West Covina for more than 10 years. Ms. Skovholt earned her Juris Doctor in 1986 from the Bolt Hall School of Law at the University of California, Berkeley. Since then, she has been actively engaged in the practice of general civil litigation with an emphasis on construction, general business, employment, and real estate litigation. Attorney Skovholt co-authored the owner chapter of the Continuing Education of the Bar Book, Mechanics, Liens, and Other Remedies, 2nd edition. She also authored issue 94-4 of the Construction Briefing, 2nd series entitled Construction Opportunities under NAFTA. Ms. Skovholt is a member of the California State Bar Association and has served as a mediator for the United States District Court for the Southern District of California in 1989. Lawyer Nancy Skovholt has served as Judge Pro Tempore in the Small Claims Division of the San Diego County Superior Court from 1989 to 2006. Please help me welcome Nancy Skovholt.
Thank you all for the invitation and for the opportunity to speak to you. And I have a singular goal today, and it is to give you so much information in so little time that you don't realize how boring this topic really is. So with that, let's please get started. So I wanted to talk to you a little bit about commercial leasing. I assume there'll be a lot of business people here, and that seems to be the case. And anybody in business is going to have to deal with commercial leases. Certainly anybody entrepreneurial is at some point going to be called upon to lease space. And leasing space in a commercial context is way different than leasing space in a residential context. So I wanted to just introduce you to some of the basic concepts that apply to commercial leasing. First of all, there are 3 types of commercial leases: the gross lease, the net lease, and the modified gross lease. I'll explain to you what those terms mean. The gross lease, you don't see that often, and you might see it for smaller spaces, but it's more similar to what you know from a residential lease. You pay your rent to the landlord, and the landlord fixes stuff. There's very little responsibility placed on the tenant under a gross lease. It can even include utilities and janitorial services as well. It's most advantageous to the tenant, hence you're not often offered it. So we don't see a whole lot of gross leases. Again, for smaller strip malls, smaller office space, a gross lease might be offered. The next type of lease is the net lease, and you've probably heard of triple net. A lot of people have heard of that and don't know what that means. You can have a single net, a double net, or a triple net lease. A single net lease is basically one where the taxes are going to be paid by the tenant. That's the single net. The double net, taxes and insurance. And the triple net, it's most common, the triple net, the tenant's called upon to pay the taxes, the insurance, and the common area maintenance fees, what we call CAM. And that is based on a pro rata share of the rentable space that the particular tenant is renting to all of the rentable space in the area, be it a shopping center or an industrial complex, etc. The triple net lease I see most frequently, although it is most commonly used in an industrial context, industrial commercial buildings as opposed to retail spaces. You can see any of these types anywhere. But the gross lease tends to be for small retail areas. The triple net lease tends to be most used in the industrial context. And so these are, oh sure, sorry, I forgot to help them all. So there's the double net, keep going. The triple net. Now, a big problem with the triple net lease is the CAM charges are assessed to you monthly. And they're based on what the CAM was, the common area maintenance was for the prior year. But what happens if the roof falls apart, or the parking lot needs to be repaired, get some sinkholes? Suddenly you can have just a massive increase in CAM charges that's very difficult to absorb for a small business person. So this is one big risk of CAM charges. And one of the things that I recommend to people, if you're going to get into a triple net lease or any lease that involves CAM charges, that you try to negotiate some kind of cap. What happens is you'll have a bad landlord who lets things go to pot, and then the building is sold to a new guy who starts doing everything. Well, that doing everything is going to cost you by the way of CAM charges. So this is, as I said, the most common type of lease for industrial properties. Then the modified gross lease is just whatever mishmash of the prior provisions you agree on. I often see modified gross, or also called modified net leases, where the only thing that the tenant is being charged is CAM. So the landlord is paying the property taxes, the landlord is paying the insurance, but still the tenant is called upon to pay a pro rata share of the common area maintenance. So see that an awful lot, and that's probably the thing I see the most. Okay, this is something that you will see in retail locations. So normally we're talking a base rent either on a gross basis or base rent on a net, double net, or triple net basis, where there's base rent plus. And of course, the base rent in a net lease is going to be lower than the base rent in gross lease because there's this additional obligation of the tenant to pay these additional charges. So the percentage rent modifier you most often see in any kind of a retail place, where there will part of the base rent will also involve a percentage rent based on a percentage, normally a percentage of gross sales. It's very commonly done, and I don't really understand why, because it's a lot more work for everybody. It's invasive from the perspective of the tenant, who now has to do regular reporting of that tenant's income to the landlord, and also has to lay open his books and records so that the landlord can come in and make sure you're not lying to him. And it's a lot more effort on both sides. So I've never had anybody really in leasing explain to me why the percentage rent modifier is so often used. I guess on the one hand, it does put the landlord on the same side as the tenant. It gives the landlord a financial incentive for the tenant to grow and do well, because the landlord will also benefit from that. So I suppose that's one perspective, but that's all I've been able to divine about why that is. So there's a lot of difference between the residential and commercial leases. On the residential lease, the landlord is normally paying for everything. On the commercial lease, there's usually some kind of net or CAM charge involved or a percentage rent involved. In the residential, the landlord pays for maintenance and repair of structural elements, whereas in commercial, the tenants are often called upon to cover everything. It's amazing when you read a commercial lease how everything is often thrown on the tenants. They are responsible for structure, they're responsible for maintenance, they have to maintain service contracts, they have to maintain warranty requirements. Even in the event of casualty loss, fire or earthquake, the obligation to rebuild can be placed on the tenant. So it is a really different perspective than you have from the residential lease, where we're very protective of our residential renters. Not so here. The tenants pay. All commercial leases are landlord oriented. So you need to understand that going in. The most important thing, and the biggest point I think I'm getting at here, is not the details, but the importance of understanding what you're signing. Not just, oh, here's the lease you want me to sign. You really need to go through it point by point, and you need to understand what the obligations are that you're taking on. Okay, so commercial leases will usually, because they're for longer term, they will usually have a built-in increase in rent periodically. Sometimes a flat number, sometimes it'll be based on some kind of parameter, cost of living increase, something like that. Again, no habitability requirements in a commercial lease, unless, of course, there's a live-work space, then there may be a habitability portion of that. Again, in the residential lease, it's up to the landlord to maintain habitability standards. In the commercial lease, even if habitability applies, normally the tenant itself is going to have a lot of responsibilities for keeping the premises up. Another important thing is I've seen commercial leases where you have to either give written notice to either continue the lease, exercise an option to renew, or give written notice to terminate the lease, so there will not be an automatic renewal of the lease term as much as a year prior to expiration of the lease. So it's very much a shame when somebody is not aware of their lease terms and they suddenly find out. Most often what happens is they fail to exercise an option timely. They realize some months before expiration that they want to do this because they've got a good rate going in. There's been a huge increase in local rentals, and they're out because they didn't exercise that option timely. So again, it's not that any of these provisions are good or bad, but it's critically important to know what you've got. You can go on to the next one. Okay, so many commercial leases, especially if you're starting in a new space or a recently remodeled space, there might be a period of time you sign a lease, but you're not expected to take possession for a while. Two things might happen. You may have negotiated for owner improvements, improvements to be accomplished by the landlord before you take possession of the space. And then you may also negotiate a period of time where you can conduct your tenant improvements. Oftentimes, commercial leases will include a tenant improvement allowance, where the landlord actually kicks you back some money because he's going to get the benefit in the long run of the improvements that you do. And often, they are set up so that your rent obligation doesn't start until after those 2 periods have passed. So you may be in possession of the premises, but you've got your, quote, free rent period, which often goes past the tenant improvement portion of time, and allows you a month or 2 free, basically, to get your feet on the ground. This is a big problem for landlords sometimes if you have a tenant that defaults right away, because you can see this tenant isn't going to work out, but there's nothing you can do to get this tenant out until they default on rent, and their first rent obligation doesn't come due for 3 or 4 months. So, yeah, it's a problem for a landlord. You can just see that things are going very, very badly. A big difference in when there is a dispute, especially a dispute that involves payment of rent. In the residential context, if a landlord gives you an eviction notice for non-payment of rent, the landlord, if he accepts rent after the notice period is expired, waives his right to go after you in an unlawful detainer. He will lose in an unlawful detainer. Not so in a commercial lease. Most commercial leases include a no waiver clause, which means even if you haven't paid your rent within the notice period, if you tender rent afterwards, the landlord can still throw you out. So you have to be a little cautious when you're trying to negotiate with a landlord and make sure if you're going to pay rent in exchange for them giving up their rights, you have to specifically negotiate that. It's not going to happen automatically as it would in a residential lease. Big thing, personal guarantees are almost always required in commercial leases, at least where we're talking smaller businesses, small corporations, small LLCs. Okay, Xerox doesn't have to give a personal guarantee. You do. So your LLC is going to lease the place, but they're not going to depend on your underfunded LLC to have that continuing rent obligation. Remember, they're committed to that space too, so they're going to want protection. That's almost never required in a residential lease.